Hello, my name is John Altmiller. I'm with the firm of Pesner, Altmiller, Melnick, Demers, and Steele. And we are here to follow up on some earlier videos that I made and Mike Derdeyn made concerning real estate litigation and establishing title. We now want to talk about some practical issues that will come up as a practitioner, and particularly as a younger practitioner. And we're going to do that in a discussion approach where Mike and I will go back and forth and talk about these issues and hopefully talk about them a little bit from start to finish. So I'm going to let Mike introduce himself now.
Thanks, John. I'm Mike Derdeyn. I'm with the law firm of Flora Pettit in Charlottesville, Virginia. And like John, the two of us do an awful lot of real estate litigation. And this is a continuation of our prior sessions. And this is intended to be a really kind of practical advice about what do you do when a client walks in the door? What are the types of things you think about? What are the types of questions you ask? And what's the kind of advice that you give in terms of what you want to accomplish for your client when they walk in with a real estate dispute, which is likely going to be a title issue, an access issue, a boundary line issue, or something like that.
Right. And I think one of the ways to start out is to talk about that first interaction that you have with the client. And, Mike and I have talked about this before. And let me ask you, Mike, what do you think about it? If somebody comes into you and says, I have an issue with adverse possession. I have a fence that's over on my property and I'm concerned the other side is claiming they have adverse possession. What kinds of things are you doing initially when you have that meeting?
Well, I mean, the things that I always have top of mind is what's the problem for the client and what's the cost for the solution, and does that make sense? I mean, that generally that's how I approach it, because a lot of there may be an issue, but when the client understands the potential cost, what it might cost to correct that issue, sometimes it's not something that they necessarily want to pursue. Sometimes, and I know you'll touch on this too, sometimes there may be proof problems and other types of things. So I think what I want to do when I meet the client is understand what the issue is, what evidence they're aware of at this point. Obviously, they're not a lawyer. They're not going to have checked title and done these other kind of things yet. And is this a problem that's capable of resolution with the neighbor, or is it something that needs to be litigated? And if it has to be litigated, how much is it going to cost this person to do so?
And I think that's very, very important at the outset, is to look at this and say, what's at stake here? And as you know, with a lot of cases, and this isn't true in a lot of areas of the law, it's very binary. Either you move your fence or you don't move your fence. Either I have an easement over your property or I don't. And there's, and partitions, which I know I touched upon in my talk, that's something where you can potentially resolve it, although there's often emotions that are running pretty high in those as well. So because you don't have a way to split it down the middle, oftentimes you are really having to say, look, if I take this case, it could go to trial. In fact, some of these cases, I find have a much higher likelihood of going to trial. And when you take a case, you have to think, am I ready to do that? Is the client ready to do that? And that's why I think what you said is important. Even before you look at the true merits of the case, before you run title, before you do any investigation, you should be looking at this and saying, what outcome could happen here? And is it worth it? And what's it likely to cost to get there? And then I think you get to some of the issues that you alluded to, which is issues of proof. What kind of evidence do I have? Is it sufficient? And, the fact that you may be suspicious of your neighbor or think that they're acting in bad faith, that's not necessarily a fact in the case. It's an impression that you have. We need to think about what the actual facts are going to be. The other thing, too, is more so in these cases, I think, than in some others, the client may be under an impression that is entirely incorrect. They may come in and tell you that they own something that they don't own. They may tell you that somebody owns something that they don't own. They may tell you that there's a contractual arrangement or an easement or something, and it's not true. And it's not that they're misleading you, it's that they don't know. So if you're looking at a parcel and an adjacent parcel, you should be running title on both of them. And you should be doing that immediately. I won't even give a client any kind of real advice until I've done that. Everything I tell them is going to be provisional at that point.
I completely agree. And you've got to run title on both parcels. And you've got to chase it back to a common grantor. And the nice thing is that doing a title search like that is not expensive.
Not at all.
$100 to get a search done like that. It gives you a wealth of information, and it allows you to really figure out legally what the rights are of the parties with respect to the legal title. Now, if it's a prescriptive easement, if it's an adverse possession issue, well, then you're obviously going outside what's of record. But what's of record is your baseline, and you got to understand what's in there.
Well, that's correct. And sometimes what you're dealing with is the construction of what's in the land records. Mm-hmm. So, and I think this gets into another topic that I wanted to segue into, which is the actual litigation. If you take a case and it's a valid case, and I would say, by the way, you talked about whether or not something's worth it. You could have an issue that doesn't seem to involve a lot of property or doesn't seem to involve the rights don't seem to be that significant, but people feel very strongly about their own property. And, there are folks here who have properties that are worth a lot of money. And, it could be that use could affect the resale value, or you could simply have somebody who just is very attached to their property. It could be family property. There's all kinds of things that could lead people to say, look, I'm willing to spend $50,000 to resolve an issue that maybe only affects the value of my property moderately, but it affects me and affects me enough because I'm not selling the property and affects my enjoyment. Or there are other reasons, but you do always, I think, want to make sure you know why people want to do things, because there's almost every reason for pursuing these is a good reason except for one, and that is if they are doing it for an improper purpose. If they're doing it, and that's very rare, but you should be testing that. You should be looking at what kind of what your client's goals are and what you think about those goals and whether or not you think you can meet them.
And that provides such value to the client. I mean, the client's going to come in and say, I have this access easement and these people have removed my fence and I want you to sue I want you to sue them because they've removed my fence. That all, and obviously people are going to be upset about anybody removing a fence. Fences aren't cheap. But as the lawyer, what you have to do is you've got to try to figure out what the legal rights of the parties are, and is it worth it to bring a claim for a fence? Can you prove that you owned the property, under which the fence was built? Who's got the rights to it? And although that's an emotional issue for the person who walks in your door, the proof issue is not emotional. And that's something you've got to get to the bottom of before you can advise the client whether or not to proceed.
Absolutely. And the other thing is, too, you might have an issue like an adverse possession or an easement issue in which you might say, look, this could go one way or the other, but there is value in resolving an unresolved title issue. I had a case one time where there was a driveway and they were sort of claiming adverse possession, and the lawyer on the other side didn't understand the law very well. But when we got through all of the discovery, we found, there's actually a really good chance that they do own this by adverse possession. But the result was my client previously had an encroachment problem. Once we litigated the case, very cheaply, I might add, and I want to get to how we can do that, she no longer had a title issue. She no longer had an encroachment. She didn't own that area any longer, but she wasn't using it anyway, and she never had. But, if she went to sell that property, somebody said, well, you've got a driveway encroaching on your property. What are you going to do about that? And the answer is now that's a resolved issue. She's not paying taxes on it. Any subsequent owners are not going to pay taxes on it, and so forth. So that's something to also take into consideration that's a little unusual about these types of cases is sometimes what you're really doing is you're getting a resolution I just settled a partition case recently where, yeah, we negotiated the money, but really what it was is its closure. I mean, it is a brother and sister, and it's the house that they grew up in. There's a lot going on there. And those negotiations involve things other than simply how much is somebody going to pay to buy the other one out.
Sure, and you're absolutely right. I mean, you never know when you walk into a piece of litigation what the resolution can be, and it can be something that ends up being beneficial to both parties. And to your point, I recently had an adverse possession case where the neighboring property owner was using a walkway across my client's property, which was encompassing, a small percentage of the property. They had a good claim. We had some defenses. It would have been very expensive to try. We ended up settling it with a boundary line adjustment where my client, we adjusted the boundary to include the walkway area in their property, and then another area of equal size towards the front of the property that the plaintiff really wasn't using went to my client. So we basically swapped two small portions of property. Each party ended up with the same amount of property at the end of the day, and avoided a cloud on the title.
We did. I had a very similar case where it was a significant, relatively significant portion that we had by adverse possession, and for reasons that I don't remember, my client was a very, very good guy. He's a lawyer, and they bought a parcel that was on the other side of my client's, or what would have been the defendant's property, and they had it was a sliver of land. I forget exactly how that happened, but what we did was we didn't even do a boundary line. What we did was we sued for adverse possession, and I told the defendant, look, we've got a very good claim. I mean, a very good claim, and let us win that claim, and we'll, in return for letting us get our relief that we've sought, which is to have this property be ours, we will grant you, this property for $1 or whatever it would be. There is a solution there, and you can actually use the litigation not in an offensive way, but or a defensive way, but as almost in a collaborative way. You get the resolution you want, and that's another thing about some of these litigations is you can end up filing litigation that, and I know we both do it, where everybody basically agrees what needs to happen. You just need a judge, because and I think I touched on this in my initial video, is that the ultimate arbiter of land records is the circuit court. And if you've got something that's unclear and you need to fix it, you need to do that suit to quiet title or declaratory judgment action. And sometimes everybody agrees or virtually agrees. Sometimes you have one malcontent, but you're using it as a tool, which again, I wanted to segue that a little bit into the practice itself. Once you've taken on a case, these cases lend themselves very often to stipulations, to agreements with regard to the authenticity of documents. And sometimes even that process itself of doing that can actually move things along, not just make it less financially burdensome for the client, but also to illuminate for both sides what the issues are. I mean, if we're arguing over an easement and what it means, let's agree what was recorded when and by whom, and what the content of those documents are. That's not something to fight about. There's no reason to fight ever about the authenticity of a deed. If somebody produces a deed and you go in and you look and it's in your title, you don't need it to be sealed or stamped or have an affidavit or anything like that. We know it's in the land records. No judge is going to be impressed by that, and I don't think your client's going to be impressed by having to pay you extra money because you're a fighter. That's not something you need to be fighting about.
Well, and that's a really good point, because even though these issues can be emotional sometimes for clients, it's important to separate that emotion from things that are undisputed, such as title records. And there's no reason not to stipulate as to what's in the title records, for example, or to stipulate as to very basic facts. When you were talking, I thought about something, and I kind of think one of the things we ought to do is step back a little bit, because sometimes, and I just wanted to raise 2 points. One is that sometimes the best advice you give is not to litigate. I mean, we're talking about these cases, and we're talking about the context of litigation, things that happen in litigation, the way you might resolve litigation. But the best advice I sometimes give is not to litigate, because sometimes you're going to have a proof problem, and a loss is worse than the status quo, or it's just simply too expensive to get there. And so advising a client that they shouldn't litigate a case is very important advice. And for those of us who litigate, it's also advice that's contrary to our financial best interests that should be taken. And I think that adds some real value to that advice from the perspective of the client, to recognize that this is truly what we believe is in their best interest, and that we're not motivated by any sort of self-interest in advising.
Well, that's go ahead. Sorry. I was going to say that I think people sometimes think, oh, well, you're a lawyer, you want to get a fee. The answer is no. What we want to do is we want to do what's best for the client. And this is particularly true for young attorneys. If that's what you do, you will get a reputation for doing that, and money will no longer be a problem, believe me.
You will have plenty of work, and will very easily be able to give the advice of, I don't think you should bring this claim. The other thing I wanted to raise, too, is a lot of times the cases I have, and I'm sure the same for you, John, come out of, you have a real estate deal that fell apart because there was an issue with the title that was found by the title insurance company. And the seller needs to cure that title insurance company, so that title insurance issue, so that they can put it back on the market and sell it. And so a lot of times I end up with cases that come to me that way. And that, I think, is for those of you who do a lot of transactional work and are thinking about perhaps stepping foot in the litigation arena, these are probably pretty good first steps for doing that, or those cases. And there are a variety of different issues that can come up. Sometimes, as you mentioned, John, these are undisputed cases. And so what you do is you prepare your complaint, you prepare a final order, you send it to the title insurance company. You say, hey, if I file this complaint and I get this order entered, is this going to satisfy you for title? And are you going to then insure title over this issue? And invariably, the title insurance company gives you the thumbs up. They give you the green light. You file, you serve. Sometimes you're serving unknown heirs. Sometimes you're serving, depending on the nature of the dispute. There's all sorts of things that all sorts of parties who may be there. But very often in those cases, you don't end up with any opposition. And ultimately, you get your order entered, and the title issue is cleared, and the person can get title. The person has marketable title and can sell. And that, I really enjoy doing those cases because that's a real service to your client, and you can do it in a very economical fashion.
Absolutely. And I think there's two issues that I take from there. One is if you're dealing with breach of contract in these types of cases, the fact that you have a contractual right, you're a buyer and you can really stick it to the seller or vice versa, doesn't mean you should. If what you're trying to do is get the deal to go through, let's figure out how to do that. And the second thing, which actually is a lesson that I'm still in the process of learning after 25 years of real estate litigation, which is always check with the transactional folks about title insurance, because marketable title is, yes, it's a concept, and yes, it's true, and yes, it comes into play sometimes because it is a higher burden than insurable title. But you should always be looking, when I do something, what impact is it going to have on the title insurance? Because a lot of times you can solve the problem by having an insurable solution, and sometimes you can have what feels like a good legal solution. You're like, this is good, everybody should be fine, and the insurance company says, no, we have an issue with that. You can yell it from the mountaintops that you're right legally all you want, but if you can't get the underwriter to sign off on it as a practical matter, you're not going to solve your client's issue. So always do that.
Well, and not to veer too far away, but this is also, when that client walks into your office with a problem, you should be thinking about title insurance. For example, if I'm having a dispute over my neighbor as to whether or not I get to use a road for access, And that access was insured by the title company. The title company, if I sue the other party, the title insurance company is not going to cover me because nobody was blocking my access. All they were doing was saying, you don't have, they're simply verbally disputing. If, however, I wait until the neighbor blocks my access, puts up a fence, puts up a locked gate, does something to block my access, well, then all of a sudden, my title, that triggers my coverage under my title insurance policy. And then I get a paid for lawyer and some amount of coverage to deal with that issue.
Yeah, that's a great point.
Always think about the title insurance, and it matters which side of the V you're on if you litigate as to whether or not you can take advantage of your insurance, of the title insurance.